Hello and welcome to LGBTQ, What Every Employer Should Know, presented by Schiff Hardin. We are pleased that you have decided to join us for this important topic. A copy of the presentation can be found in the Handouts section located on the left-hand side of your screen. Questions can be submitted at any time by using the chat feature in the lower left-hand corner of your screen. Our speaker will answer questions at the conclusion of today's presentation. I would now like to introduce today's speaker, Tracey Wallace. Welcome, Tracey. The floor is yours.
Thank you very much. Good afternoon, everybody, and thank you for joining us. I want to tell you a little bit about what we're going to talk about today, which is LGBTQ. The first thing that we're going to do is talk about some different terms, and then we're going to go right into the legal landscape for LGBTQ employees in the public sector, when working for government contractors, in the private sector. We're then going to take a look at state and municipal protections for LGBT workers, and then finish with some suggested best practices. So let's first talk about some terms that you may be familiar with or may not be familiar with. What is LGBTQ? Most people usually hear the term LGBT. Q on the end stands for questioning. That person is still trying to figure out what their sexual orientation is. They haven't decided one way or the other yet, and so they refer to themselves as questioning. It also may refer to some employees who don't recognize themselves as being one sex over the other. They may use the terms unisex, or they may use just a regular pronoun as they. So some of these terms you are familiar with: lesbian, gay, bisexual, transgender. Transgender means an individual who has a gender identity or gender expression that differs from their assigned sex. So you may have someone who was born female who identifies as the gender male, or you may have someone born male who identifies as the gender female. And their gender expression comes out where you may see someone who was born female, but they may wear more masculine clothes, and you may see someone who was born male and they may wear more feminine clothes. The next thing you're going to talk about is gender reassignment, and this is more commonly known as transitioning. It's where you may have an employee who is in the process of changing from one's gender to the gender with which they identify. And transitioning could be the process of going from either female to male or male to female. Coming out, that's letting your friends or employers or other people know that you are homosexual. Sexual orientation deals with what you believe in terms of being attracted to people of the same sex. And my sexual orientation is I'm gay or I am lesbian. So in the past, there have been and there are still issues and concerns with respect to LGBT employees and how they're treated in their employment place of business. And some of the problems that you commonly see associated with LGBT discrimination are high turnover. Just like any other employee, if they perceive the place of business to be a hostile work environment, they're more likely to leave. And so then you'll see an employer have more significant issues with respect to high turnover, with respect to bringing on other employees. You also see that in terms of low productivity. Another issue that is really raising its head right now is that polling shows that younger employees are more likely to leave workplaces that they believe are not as accepting as they should be. So if you're looking to get younger employees, if you're looking to get employees who are sort of the best and the brightest, they may have significant concerns with an employment place that they believe is not as accepting. You're also starting to see more costly litigation. And costly litigation are cases that are being brought by the EEOC, as well as cases that are being brought by private plaintiffs. Business loss, you see that with respect to businesses who are not perceived to be as welcoming to the LGBTQ community, that are boycotted. because of their treatment of the LGBT community and or the perceived treatment of employees. And why is this important? This is important because estimates put the LGBTQ discretionary spending market at over $800 billion annually. So when there is a boycott of a particular type of business or a particular business, that is a significant spending market that people are not being allowed to take advantage of. So what legal protections are there that employers should be aware of? Let's first talk about protection when working for public entities. When working for public entities, protection for LGBTQ employees will most likely be based on the Equal Protection Clause. That has been a rather successful argument in recent years. And as you see from the case that is before you, Gill versus Devlin, that is the argument that was raised in that case. And the Gill versus Devlin case involved a professor who alleged that she was denied a full-time position because of her sexual orientation. She filed a lawsuit, and Tarrant County Community College moved to dismiss the lawsuit. The motion to dismiss was denied by Judge Terry Means, and here in the Northern District of Texas, Judge Terry Means is a long-time judge. He's very conservative. He is actually located in Fort Worth. And so when Judge Means wrote the order denying the motion to dismiss, a lot of lawyers and people took notice here because of his past history. And I can tell you that shortly thereafter the motion to dismiss was denied, the case was settled for $160,000. And with respect to cases with public entities, the Equal Protection Clause is really the argument that is going to be made that the rights have been violated. It has been a rather successful argument. You've seen private attorneys bring that argument. You've also seen organizations like Lambda Legal who have brought cases against public entities based on the Equal Protection Clause, and they're finding success with that type of litigation. In terms of protections, federal protections, there really isn't a federal statute that protects LGBTQ employees, so there have been different things done in recent years to offer those protections, and one of the things that has been done was when President Obama in 2014 amended Executive Order 11246. 11246 was amended by Executive Order 13672, and what that did basically was add the words sexual orientation or gender identity, and it was specifically meant to prohibit discrimination based on sexual orientation or gender identity, and it applies to those government contractors or subcontractors who do over $10,000 in government business in 1 year. The effective date of the amendment to Executive Order 11246 is April 8, 2015, and so it applies to contracts that are entered into after that date. It requires that contractors and subcontractors specifically put into their contracts that they will not prohibit or they will not discriminate based on sexual orientation or gender identity. It also requires that contractors and subcontractors have restroom policies, which cannot be discriminatory on the basis of sexual orientation or gender identity. It does not, however, require contractors or subcontractors to set goals per se for employing persons on the basis of their sexual orientation or gender identity. It also does not require contractors or subcontractors to collect and maintain statistics. Now, with respect to Executive Order 11246 and government contractors and subcontractors, the OFCCP will be accepting complaints of employment discrimination on the basis of sexual orientation or gender identity and will be investigating those as well. And then you also have and we'll talk about this a little later, employees having the option now of filing with the EEOC, which has been making some significant movement in the area of sexual orientation discrimination, and we'll discuss that. More shortly. So, what about any sort of protection when working for private entities? As I said before, there is no federal statute that protects the LGBTQ employees. So what you have seen develop are specific case law that deals with protections for LGBTQ employees. Now, the first case, or the seminal case that actually talked about or is actually used by LGBTQ employees regarding discrimination is the case of Pricewaterhouse versus Hopkins, which is a 1989 United States Supreme Court case. And this case had to do with sexual stereotyping. And basically in that case, just to tell you rather briefly, you had a CPA in that case who was a high performer for the company and was up for partnership. She was ultimately not chosen for partnership, and when she inquired as to why she was not chosen, based upon her numbers and based upon the number of clients that she had been able to get, she was told that in order to improve her chances for partnership, she should walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry. And this case, when it went to the Supreme Court, the Supreme Court held that that is a violation of Title VII, and that is a violation of Title VII based on sex, because what you're talking about then is someone not complying to typical gender stereotypes. So with that baseline case, what you have seen evolve over the years are cases from LGBTQ employees who have used gender stereotyping as a basis to bring lawsuits. And this has had some success. However, in those particular type of cases, they have to be really careful in order to state a claim for sexual stereotyping as opposed to sexual orientation discrimination. And courts over the years it's been very difficult for them to distinguish between the two. So what you will find are cases where the claim is actually sex stereotyping, but when you look at the facts, the complaint has to do with sexual orientation discrimination. It's not more so that someone said you need to conform to what your gender standards are. It's more so I was called an epithet, or I was harassed by another employee because of my sexual orientation. And when you had cases like that, those cases were dismissed by the courts based on the fact that Title VII does not specifically cover discrimination based upon sexual orientation. And that has been the law of the land for a great number of years. Recently, however, there has been some movement regarding sexual orientation discrimination. Now, that movement started with the Equal Opportunity Employment Commission and the Macy case, most specifically, Macy versus Bureau of Alcohol, Tobacco, and Firearms. In that case, Macy applied for an open position with the ATF and was informed that the application was going to be successful. Later on, Macy called back and said that she was going to be in the process of transitioning, and when she made that announcement, she was told that the position was no longer available. Macy thereafter found out that someone else had been hired for the position. She filed a complaint, administrative complaint with the EEOC, and when she filed that administrative complaint with the EEOC, she checked sex. Now, initially, that complaint was dismissed by the EEOC because it said that Title VII does not cover sexual orientation or transgender discrimination based on sex. Macy appealed that, and on appeal, the EEOC said that yes, discrimination because of sexual orientation as well as gender identity is discrimination because of sex, and that is covered under Title VII. Now, this is the first time that a ruling of this type had been made by either a court or by any administrative body with respect to covering laws in this particular area. Now, after you see the Macy decision happen, the EEOC's interpretation not only changed, but then they also said that in 2012, after this decision was issued, the EEOC identified LGBT coverage under Title VII as an emerging issue. And what this meant in terms of the EEOC is that the EEOC would be looking for more cases like this, and that they would also devote more resources to cases like this as well. And so what we see happening after the Macy decision is the EEOC being true to its word and looking for more cases involving sexual orientation or gender identity, and also devoting more resources to it. A couple of cases that came out after the Macy decision, you see the Jameson versus U.S. Postal Service decision, which was another EEOC appeal, where the EEOC held that intentional misuse of a transgender employee's new name and pronoun may constitute sex-based discrimination and or harassment. You see the Lusardi case, where the EEOC holds that restrictions on a transgender woman's ability to use a common female restroom constitutes disparate treatment. And then finally, you see the Baldwin case, holding that discrimination on the basis of sexual orientation necessarily states a claim for discrimination under Title VII. Now, these are by no means the only cases, the only administrative cases that the EEOC reviewed at this time, but these are cases typical of the types of holdings that you started to see coming out of the EEOC with respect to gender identity and sexual orientation discrimination. Now, the EEOC did not just limit itself to administrative decisions with respect to discrimination for gender identity or sexual orientation. You also begin to see the EEOC bringing cases against private companies. And a couple of cases were brought by the EEOC on the same day, March 1st, 2016, where you had the EEOC versus pallet companies, EEOC versus Scott Medical Center, and they filed those two lawsuits on the same day. The pallet companies case dealt with harassment of a lesbian employee under Title VII, involving comments about sexual orientation and appearance. That case was settled in June of this year, and the company agreed to pay a settlement of $202,000. Approximately $180,000 went to the plaintiff, and the company also agreed to donate an additional $20,000 to the Human Rights Campaign. Now, with respect to the EEOC versus Scott Medical Center case, that case is currently being litigated, and as of last week, a motion to dismiss was filed by Scott Medical Center on the basis that Title VII does not cover sexual orientation. Now, this is an important point because even though you see the EEOC having these administrative decisions and bringing these cases against private companies under Title VII, the question is, what are the courts doing? Now, the courts are, as far as I've been able to see from the cases that I reviewed, are still holding that Title VII does not specifically bar discrimination based upon sexual orientation, and they are dismissing these claims. Now, this was a question in the minds of some people after the EEOC started treating LGBTQ discrimination as an emerging issue. because typically courts do give some deference to what the EEOC is doing, but it has been interesting to see that with respect to the argument of sexual orientation discrimination under Title VII, courts are still dismissing those claims because they're not covered. Now, what's also interesting is that in these opinions where the courts are dismissing these cases, like the Omnicon Group decision, as well as the decision that came out last week from the Seventh Circuit, the Hively case, when you read those opinions, the judges almost seem apologetic that they have to dismiss the case, but they are saying that Title VII does not extend to sexual orientation discrimination, and they are dismissing those cases. However, even though courts are dismissing these cases, I still believe that the EEOC is going to continue to aggressively pursue sexual orientation discrimination under Title VII. Now, whether or not the EEOC is going to continue to be successful with that, or whether or not they are going to be able to continue to vote resources to that, is in some ways going to depend upon the upcoming election. But I think that as it stands right now, the EEOC is going to continue to aggressively pursue those cases and even bring lawsuits against private companies because of discrimination based upon sexual orientation. And now, while the companies may ultimately be successful in those cases, it's going to involve some significant litigation costs, because when you are talking about the EEOC, they do have the ability to bring the entire force of the federal government in a particular lawsuit. But even though they do that, I think in the end, and I think that this is what's going to happen with the EEOC versus Scott case, I think that they are going to be dismissed because Title VII specifically does not cover sexual orientation discrimination. And if that were just the only place to stop, we could end the discussion. But the federal landscape is not the only place where you will see laws regarding discrimination against LGBTQ employees. You also need to take a look at what your state laws are holding. In the map that I'm showing you right now, and this map is from the Movement Advancement Program, it shows you throughout the United States where you have those states that have LGBTQ protections and and those states that do not. The dark green states with a T have employment non-discrimination laws that cover sexual orientation and gender identity. And this amounts to 20 states plus the District of Columbia. The light green states like Wisconsin and New Hampshire, these states have employment non-discrimination laws that cover only sexual orientation. Now, the light states like Texas, Oklahoma, Kansas, Nebraska, Arizona, these states do not have employment discrimination laws covering sexual orientation or gender identity. And in those states where you see the hazard signs like Arkansas, Tennessee, and North Carolina, those states have laws preventing passage or enforcement of local non-discrimination laws. Now, with respect to those states that do have non-discrimination laws, for example, California and New York, both have state laws prohibiting discrimination on the basis of sexual orientation and gender identity. And it is really important to become familiar with whatever LGBT discrimination laws your state may have, because those laws may carry not only monetary damages, but they also may carry significant fines and penalties. Another thing that you want to take a look at in terms of LGBT discrimination laws, you want to take a look at local and municipal ordinances. And not only do you need to be concerned with state laws, but you also need to be concerned with local and municipal protections for LGBTQ employees. Over 200 cities and counties have laws or policies prohibiting discrimination on the basis of sexual orientation. New York City has a law. Dallas has a law. Los Angeles has a law. Atlanta, Portland. There is a complete list of cities and counties that have protections for LGBT employees, and those protections can be quite significant. For example, in New York City, if you have a complaint against a business involving sexual orientation or gender identity, the fines can be anywhere from $150,000 to $200,000 based upon a determination of whether or not the act was malicious or not. The city of Dallas, for example, has local ordinances that are not as punitive as New York City, but they do exist. Now, the local ordinances in Dallas apply to city contractors and apply to private contractors as well, and that is a distinction that you will need to find out based upon your local ordinances, whether or not they only apply to public employees, whether or not they apply to public contractors, and whether or not they apply to private companies. So for Dallas County, as I was saying, they have a local ordinance that protects public employees, but it also applies to contractors and applies to private companies. And it offers protections from discrimination based upon sexual orientation or gender identity. In Dallas County, there is a process where you can file a complaint. The complaint will be investigated. You can present evidence, and a decision will be made. Now, in Dallas County, the outcome is usually in terms of fines and penalties, and they are not that significant. But what you may have in other places, you may have situations where if you have a contract with a local government or a local government entity, you may lose that contract, or you may be debarred from having any future contracts with local government entities. So it's really important to take a look at where those LGBTQ protections are and what they actually offer and how you need to comply with them so that you're not open to fines and penalties, and that you're also not, if you are a contractor with a local governmental entity, not in danger of losing that local contract and being debarred from having future contracts. Now, there are at least 61 local governments that have used their spending powers to require contractors to adopt non-discrimination, and that word should be affirmative action policies. And if the local contractors do not do that, then they face fines and penalties, and as I was saying, loss of contract and then even debarment. And there are particular counties like King County and Seattle in Washington State, where their local ordinances or protections also provide for an individual right of action for employees of the local contractors, and they have the ability to go file a lawsuit in that particular area. So it's really important to see if that is something that is involved with respect to your contract. There are also others that confer private rights of action, as I was just speaking of, Allegheny County in Pennsylvania, and I believe also recently Eric County in Pennsylvania. They also allow for private rights of actions of employees against private companies in that area who they alleged had LGBT or gender identity discrimination. In those particular counties, there can be a conciliation process. They can hold hearings. They can issue injunctions. They can award back pay, reinstatement, and other compensatory damages to those particular employees. So I really cannot stress enough that it is important to figure out and find out what your local city or your local county has in terms of LGBTQ protections for employees. So let's talk a little bit about best practices, and these are things that you may want to institute at your business when dealing with LGBTQ employees. If you have not already, what you may want to do is to revisit your non-discrimination policies. Specifically, if you have an employee handbook, if you have any handwritten policies or procedures, and they have non-discrimination language in them, you will want to go back and revisit that language to make sure that they include sexual orientation or gender identity. Now, last summer, June, the Supreme Court issued the Obergefell versus Hodges decision. And the biggest impact that this decision had on employers are with respect to policies and procedures. If you have policies and procedures and you have not revisited them since the Obergefell decision, you will want to do that. And the reason that I say that is because if you are offering particular benefits to employees, you will also, to employees who are heterosexual and you're offering to their spouses, you will also need to go back and take a look at those policies and make sure that you're offering them as well to same-sex couples. One example is our leave policies. Before the Obergefell decision came down, the Department of Labor had issued regulations where it was going to change FMLA term spouse and include same-sex couples, and there was quite a bit of discussion about when that was going to be instituted and whether or not that needed to be delayed. And in fact, there was actually a couple of lawsuits that were filed, one out of Texas, to delay the DOL regulations from taking effect. And once those lawsuits were filed, nothing was really done with respect to those lawsuits because everyone knew that the Supreme Court was going to be issuing the Obergefell decision. And after the Obergefell decision came down, those lawsuits and the DOL policy sort of became mute because the Obergefell decision was based upon equal protection and that LGBT couples had the right to marry. And so now where you have policies and procedures that are offered to heterosexual couples, that are offered to opposite-sex married couples, you need to go back and revisit those and offer them to same-sex couples. That's whether or not you have a particular leave policy. That's whether or not you offer certain benefits to married couples. You have to go back and change that language. If you have policies that refer to wife or husband, you may want to go back and change those and just refer to spouse. So Obergefell had more of an effect on employment policies with respect to benefits and insurance and things like that, or other issues where it had an effect. I think we have great ERISA counsel who can answer any questions about that. Another best practice that you want to consider is conducting training for your employees, not only with respect to diversity, but also anti-harassment training, what conduct that you might believe would be more appropriate when dealing with LGBTQ employees, how LGBTQ employees would like to be referred to, the proper pronouns that are going to be used to LGBTQ employees, training that offers that type of information to your employee. Another thing that you want to take a look at, especially in light of all of the litigation that's going on right now around sexual orientation and gender identity, are your dress codes. There are dress codes from each employer, but they are usually delineated based upon the sex of the employee. Male employees are required to dress this way. Female employees are required to dress another way. And so what you will want to do is to go back and take a look at your dress codes to make sure that they're not gender stereotyping, or they are not running afoul of what anyone would classify as their gender identity or gender expression. And I think that this is more important because of all of the litigation you're seeing coming out right now. Another issue that you want to take a look at is the appropriate use of pronouns. How do employees want to be referred to themselves? If an employee is transitioning, how does that employee want to be referred to? Does that employee want to be referred to as she or he? Does that employee specifically want to be called by the name that they are answering to? Does the employee want to be specifically referred to as they, someone who identifies as unisex and does not specifically identify as either male or female? You need to take a look at the use of your pronouns in the workplace, especially if you have an employee who is transitioning from either male to female or female to male. And the reason that this is important, the cases that the EEOC has brought, and I believe that they will continue to bring, a good many of those cases had to deal with gender identity and gender expression and the use of the proper pronoun when referring to a particular employee. So that's something that you want to go in and take a look at. Restroom access. I get an awful lot of questions from clients regarding restroom access. That is something that you need to go back and take a look at and draft policies concerning restroom access. We saw cases from the EEOC that were brought specifically because a transitioning individual was not allowed to use the restroom that corresponded to the gender that they identified with. And that is something where the outcome may be that the employer specifically says the person that is transitioning has the right to go and use the bathroom with whatever gender they identify with. And there have been some employers who have gone on and created unisex bathrooms because they wanted to be respectful of the transitioning employee, but they also wanted to be cognizant of any issues that other employees would have with respect to the transitioning process. But be that as it may, there should be some policy somewhere that discusses restroom access and how that's going to be done when you have transitioning employees that work for you. The next issue is guidelines for managing workplace transition. If you have not created guidelines for managing workplace transition, I would suggest that you do so. And these guidelines can run the gamut of appointing a particular HR person or appointing a particular person in your company to deal with issues for employees who are transitioning, in terms of restroom access, in terms of how the employee wants to be referred to, in terms of the communications that you have with your other employees about someone who's transitioning. And those communications are usually occurring if you have the authority from that transition employee to share that information. Some people, some transitioning employees are happy to share that information because they want their coworkers to know, and they want their coworkers to refer to them by the name that they identify with, and they also want to be able to be referred to in the proper pronoun. So there's a whole process that you will have with respect to employees who are transitioning, and employers should take a look at the guidelines for managing those, not only with respect to your workplace, but also with respect to seeing the types of litigations that are being brought by the EEOC and now private plaintiffs. Administrative and personnel records. If you have an employee who is transitioning, the question becomes, after that employee has told you that they are transitioning, what happens with your administrative and personnel records? The administrative and personnel records need to be changed to refer to the proper pronoun. There are some that can be changed. There are some records that cannot be changed because the state law does not provide for it. And one example of that are driver's license records. If you have that in your personnel files, depending upon which state you are in, they most likely have to remain with the sex that person was born with. And the reason that is, in some states, the law does not allow for those records to be changed unless and until the person has gone through the entire transitioning process and changed their sex, and as well as petitioned the court. I know here in Texas there is a law that says that the driver's license cannot be changed unless and until the person has gone through the entire transitioning process and has changed from male to female or female to male. There have been cases where people have gone to the courts and have sought to have judges change their name on their driver's license, and those claims have been refused because Texas state law does not allow that. So that is something that needs to be looked at as well. What does the law in your particular area allow for? And last but not least, taking a look at privacy and confidentiality. As I was discussing before, there are some employees who are happy to go through the interactive process with their employer and also share that information with their coworkers so that they are referred to by the right name and the right pronoun. There are some other employees, on the other hand, who do not want that information to be made available until a certain point in time. And it's really necessary to go through the interactive process for those particular employees to determine what it is they want to do and how they want to be referred to and what they're comfortable with. And again, the reason that is important is not only for your workplace, but also because of the governmental entities like the EEOC that are bringing claims based on that. And it's certainly these are certainly things that you want to take a look at if you're a governmental contractor or a governmental subcontractor, and also if you are in one of those states that specifically has LGBTQ protections and discrimination laws, or one of those local cities or counties that also has LGBTQ anti-discrimination laws. So it's really important to know what is required at every level with respect to if you're a public entity like a college or university, or if you are a private governmental contractor, or if you're a private employee. It's really important to see what those laws say. So we have come to the end of our presentation. And if there are no questions, I would thank everybody for their time. And if you have any questions later on regarding the topics that we have covered today, please do not hesitate to send me an email, and I will answer whatever question you may have.
Thank you. That completes our presentation for today. We hope you've enjoyed LGBTQ, what every employer should know. Thank you for your participation. and we look forward to having you back for other events in the future. Have a wonderful day.